Today, we're diving into a real collision of two huge American issues: the Second Amendment right to own a gun and the critical need to protect people from domestic violence. We're going to break down how one single court case tries to untangle this very difficult and very dangerous combination. Okay, let's get right into it. So, this is the question at the heart of everything. We're not talking about a violent felony here, but a misdemeanor conviction for domestic violence. Is that enough to justify a lifetime ban on owning a gun? Well, a federal court had to tackle this exact question, and you know what? Their answer shows a massive shift in how we have to think about gun laws in America today. The case we're looking at is called United States versus Simmons. It's all about a man named Valdez Simmons and a federal law, specifically Section 922 G9. This law says that if you've been convicted of a misdemeanor crime of domestic violence, you are not allowed to have a gun. The whole point of this law was to close what lawmakers saw as a really dangerous loophole. Because let's face it, guns and domestic violence are a deadly mix. So how did we even get here? Let's just quickly walk through the timeline. Back in 2012, Valdez Simmons was convicted of assaulting the mother of his child. Fast forward to 2020, and he gets arrested in the Bronx because police find him with a pistol. But then, in 2022, the Supreme Court completely changed the game with a landmark ruling called Bruen. And suddenly, this gave Simmons a whole new way to challenge the gun ban, which led to this major appeals court decision in 2025. So what was the verdict? Well, the court said the ban is constitutional. But, and this is the big but, the way they got to that answer is the real story. The old ways of deciding these cases, totally thrown out the window. The court had to follow a brand new and frankly much more complicated rulebook from the Supreme Court. And that journey is what's so fascinating here. All right, to really get what happened, we need to understand this new rulebook. It all comes from that big case, Bruen. And it created a test that has totally reshaped how every court in the country has to look at Second Amendment cases. The Bruen test has two steps that sound pretty simple on the surface. Step 1, the court asks, does the plain text of the Second Amendment even cover this person and what they did? And if the answer is yes, then Step 2 kicks in. The government now has to prove that its gun law is consistent with the nation's historical tradition of regulating guns. And that second part, the history part, that is the new, really challenging hurdle. Okay, so the court dives into Step 1. The Second Amendment, right? It protects the right of the people. So the big question for the court was, is Valdez Simmons, a guy with a domestic violence conviction, is he considered one of the people? And the court's answer was a clear yes. Now this is really interesting. The court said the phrase "the people" means all Americans, not just some perfect law-abiding group. So even someone with a criminal record like Simmons is still part of the people, and his right is presumptively protected. That means the government couldn't just throw out his case. They had to move on to the much harder second step. And that brings us to Step 2, the history lesson. This is where things get really tricky. The burden was now totally on the government. They had to go digging through centuries-old laws to prove that banning domestic abusers from owning guns is something that aligns with American traditions from way back when the country was founded. To do this, they needed to find something called a historical analog. Now, that doesn't mean they had to find a perfect 18th century law that banned domestic abusers from owning guns. No, instead, they just had to find old laws that were built on the same basic idea. In this case, the idea of taking guns away from people who were considered dangerous to other people. So what did the court actually look at? Well, they found a few different types of old laws. First, there were surety laws. These let judges force people they suspected of future violence, and that included spousal abuse, to post a bond, basically money, to guarantee they'd keep the peace. Then there were going armed laws, which made it illegal to carry weapons around in a way that terrified your neighbors. And finally, and the court was very clear about this, there were laws that disarmed entire groups that were seen as a threat back then, like political enemies or Native Americans. Now the court said, look, these laws are obviously offensive to us today, but they're still relevant because they show a history of legislatures deciding certain groups were too dangerous to have guns. You know, when you boil it all down, all these old laws point to one core principle. And the court leaned on a recent Supreme Court quote that really nails it.
It says that taken together, our history shows that when someone poses a clear threat of physical violence, well, that person can be disarmed. It's an idea that's been around for a long, long time.
Now, Simmons's team had a pretty clever argument. They said, hey, history only supports disarming serious felons. A misdemeanor isn't serious enough. But the court didn't buy it. They pointed out that the law doesn't ban guns for just any misdemeanor. It specifically targets violent domestic abuse. The court said the label, felony or misdemeanor, that's not what matters. What matters is that Congress has identified this specific group as dangerous because of their proven history of violence. So after going through the text and then the history, just like that new Bruen test demands, the court was ready to make its final call. And the final conclusion was this. The modern law banning domestic abusers from owning guns fits neatly within that long-standing American tradition. The court basically drew a straight line from those old historical laws to this one today. The law stands, they said, not because it's some radical new idea, but because it's just a modern application of a very old one. And get this court wasn't some outlier. Not at all. In fact, 100%. Every single federal circuit court that has reviewed this law since the Bruen decision has reached the exact same conclusion. There is a solid, unanimous agreement among these courts that this law is constitutional, even under the Supreme Court's tough new history test. So, at the end of the day, we're left with this huge takeaway. The Supreme Court has forced our legal system to look to the 1700s and 1800s to justify the laws of today. And while that approach upheld this particular law, it leaves us with a massive question for the future. In a modern world with problems the founders could never have dreamed of, what does it really mean for a gun law to be consistent with our nation's historical tradition? That's the question everyone's going to be grappling with for a long time to come.